Breaking. Supreme Court annuls Buhari's Executive Order 010. Welcome to the news, and please subscribe to our channel to get more hot, juicy updates from us. Please click on the notification bell. Thank you. The Supreme Court has nullified President Muhammadu Buhari's Executive Order 10E010 on the funding of state judiciary and legislature. In a split ruling today, a 7-man panel of justices and the order was unlawful and unconstitutional. Sentel, I don't know why they kicked against this order. Hey, I don't know why they kicked against this order. But it is really surprising that the judiciary actually did this. Sincerely, I'm impressed. So that means they're no longer, they're not very independent. I hope it is so. I hope it is so. The news in detail, please stay with us. According to the majority ruling by the justices, President Buhari exceeded his constitutional powers in issuing E010. The judgment was on the suit filed by the 36 states on the funding of a state judiciary and legislature. The order sought to give financial autonomy for the two arms of government at the state level by deducting money due to them from the statutory allocation to the states. Presidential Executive Order number 0010 of 2020. Presidential Executive Order number 0010 by the President of the Federal Republic of Nigeria for the implementation of financial autonomy for the state legislature and state judiciary and for all the related matters. Whereas the Presidential Implementation Committee was constituted to fashion out strategies and modalities for the implementation of a financial autonomy for the state legislature and state judiciary in compliance with Section 1NT1M1ĐÂng of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Taking into law's consideration all other applicable laws, instruments, conventions, and regulations which provide for financial autonomy at the state tier of government. Whereas implementation of financial autonomy of a state legislature and state judiciary will strengthen the institutions at the state tier of government and make them more independent and accountable in line with the tenets of democracy as enshrined by the Constitution of the Federal Republic of Nigeria, 1999, as amended, and by the power vested in me as the President of the Federal Republic of Nigeria under Section 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which extends to the execution and maintenance of the Constitution. Laws made by the National Assembly, including but not limited to Section 1NT1M1ǳ of the 1999 Constitution as amended, which guarantee financial autonomy of a state legislature and state judiciary. Now, therefore, I, Muhammadu Buhari, President of the Federal Republic of Nigeria, in exercise of the power conferred on me, do hereby order as follows. Appropriation, authorization, orders, etc. A. Without prejudice to any applicable laws, legislations, and conventions at the state tier of government, which also provides for financial autonomy of a state legislature and state judiciary. Allocation of appropriated funds to the state legislature and state judiciary in the state appropriation laws in the annual budget of a state shall be a charge upon the consolidated revenue fund of a state as a first-line charge. B. The account general of a federation shall by this order and such any other orders, regulation or guidelines as may be issued by the Attorney General of the Federation and Minister of Justice authorize the deduction from source and the cost of Federation's account, allocation from the money allocated to any state of the Federation that fails to release allocation meant for the state legislature and state judiciary in line with the financial autonomy guaranteed by Section 1NT1M1ǳ of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Determination of the budget notwithstanding the provisions of any existing law, convention, or regulation other than the Constitution of the Federal Republic of Nigeria, 1999, as amended, providing for appropriation or management of funds at the state tier of government as follows. Every state government of the Federation shall set up a committee from the commencement of this executive order, comprising the Commissioner of Finance, Accountant General of a state, representative of the State Budget Office, Chief Registrars of the State High Court, Sharia Court of Appeal, and Customary Court of Appeal, where applicable, the Clerk to the State House of Assembly, and the Secretary of a State Judicial Service Committee or Commission, where applicable, determine and ascertain from the revenue profile of a state a workable budget for each arm of a state government based on the requests and needs of the accounting officers, and the committee shall be given and accorded legal recognition and the various relevant appropriation of funds, management laws of the state. Creation of State Judiciary Budget Committee. A. For the purpose of appropriation to the State Judiciary. Each State Judiciary of a Federation shall set up a State Judiciary Budget Committee in this order referred to as a committee, to serve as an administrative body to prepare, administer, and implement the budget of a state judiciary with such modifications as may be required to meet the needs of a state judiciary. B. The committee should consist of a state chief judge as the chairman, with a grand Qadi, Sharia Court of Appeal, the president, Customary Court of Appeal, where applicable, and 2 members of a Judicial Service Committee or Judicial Service Commission to be appointed by the Chief Judge, in consultation with other members of the committee to serve as members. C. The Chief Registrar of a State High Court is to serve as Secretary. D. The modalities of budget preparations and implementation shall include but not limited to the following. I. Upon the receipt of the budget estimates of the fiscal year for the State Judiciary, the State Judiciary Budget Committee shall invite all the accounting officers of the various courts or judicial bodies to defend their budget estimate. 2. The budget estimate for courts and judicial bodies shall be based on expenditure line items given to them by the State Judiciary Budget Committee, which shall be defended before the State House of Assembly. And 3. Upon the appropriation of funds, the State Judiciary Budget Committee shall, on a monthly basis or as the case may be, request the Budget Office of a state to release the statutory allocation for the quarter or monthly, and the authority to incur expenditure AIE shall be raised by the Office of the Accountant General of a state for the release of the fund to all the heads of courts and judicial bodies in line with the appropriation law. Tell me what is here not to like. But he, as a professional of law, as vice president, did he not study the whole issue before the president made the EO? That handbag, oh my God, is that one ever considered in any decision making? Judiciary is proving the right because it has to do with their personal interest as a body. So there is EO10 that can be negated in Buhari'S inhuman activities. Oh, it is actually inhuman. Okay, on this note, we have come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.